Okay, so now we're going to begin with talking about what mock trial generally is and how the examinations in mock trial are carried out. So first of all, what is mock trial? Mock trial basically follows the process of a criminal case in a lower court. And because we're following the IMTC standards, it's mainly replicating how the US criminal case system works. And it contains a judge, the prosecution, and the defense attorneys, and the prosecution and defense witnesses. So while a normal court does have a jury, in the case of mock trial, we don't have juries. So the participants are just going to act as though there was a jury, but the final verdict of which team wins and which team scores a little lower is made by the judge. So continue. What is mock trial not? Mock trial is definitely not debate. So I don't know if any of you have had like previous experiences with debate, but debate basically necessitates you to speak in very quick, sharp arguments that are just thrown across the floor. But mock trial is not that. In mock trial, we slow down and we tell a story and make sure that story is repeated again and again and is very clear to the judge. It's not about speaking the most, and it's not really even about making the most logically coherent points. Again, it's about framing a narrative, like the story that you have behind the case, and presenting it in a way that's very vivid and clear and the most emotionally moving. So mock trial is very performative. You could actually think of it more as like a drama play than an argument course. Emotions matter a lot. So like in the ethos, logos, and pathos, I would say matters the most in mock trial. Like how are you creating an emotional resonance with the audience, right? You need to pretend like there's a jury, and a jury is composed of normal, ordinary people that you could meet in the street. So they are not very advanced in terms of legal jargon and professional terms. It's all about making the story the most impactful and resonant to people who really aren't that professional, who are just normal people. You need to appeal to their sense of judgment, which makes emotions matter a lot. Now, for every mock trial competition, you'll be given a case packet. And the case packet basically defines the case. It gives you the stipulations, the special instructions, the jury instructions, the indictment, the case law, the evidence, and the affidavits and depositions. So the first few is basically just laws that are already that are like, for example, like exceptions and whatsoever that are directed towards the case in particular. Stipulations are like facts already made clear that you're not going to debate about. Special instructions, jury instructions, these vary case by case and they're pretty straightforward. Hold on, let me admit somebody in. And the case law is like a set of law that may apply to this case. Again, it's varies case by case. And the affidavits and depositions are the most important, in my opinion, because they are the facts of each witness, and you're going to have to craft your overall story and narrative around what's in the affidavit. And there are basically three roles in mock trial. So there's the attorney who asks the witnesses questions and object to opponents' questions or responses, and witnesses who respond to their attorney's questions and plays their witness's character. The witness roles will be outlined in the affidavit session in the case packet. Also, there's the judge, but the judge is not a participant. They preside over the case and decide what is allowed and not allowed. For example, which evidence can be entered and whether like an objection is valid or not. So not all of you are going to get to be a judge because most of you are just participating in a mock trial competition. So you'll either be an attorney or a witness. Now, I'm going to introduce the components of mock trial. So there's the opening statement, the direct examinations of witnesses, the cross-examination of witnesses, and the closing statements. And our focus for today would be on direct examinations of witnesses. So what is a direct examination? A direct examination is basically when the attorney asks their own witness. For example, the defense witness would give a direct examination to the defendant. That's basically you. For example, if you are the attorney, you are giving your witness a chance to tell their side of the story. You're guiding them through a narrative. And you are basically working together with your witness to demonstrate your case. So think of it as a conversation, not an interrogation. Think of how you would talk to your friend to get to know their story more. Don't ask yes or no questions because that's an interrogation. You don't want to cut your witness short. You want the jury to hear as much as possible from your witness because, first of all, it humanizes your witness. It makes them seem more like a living person, and this would create an emotional effect on the jury. And also, you just want to get as many facts out there from your side as possible. So it's harder for the other side to come and build their case that frames your defendant as an evil person, basically. So what makes a good directing attorney when you are an attorney in a direct examination? So first of all, like I said, you should ask short questions that the hypothetical jury can easily digest. So the questions shouldn't be very long and complicated because the jury might not follow. And if they don't follow, they don't know what you are talking about. And that's basically a question wasted. And don't ask leading questions, which are, like I said, yes or no questions. For example, do not ask your witness, you were there on the 3rd of June, weren't you? Because this, first of all, does not give your witness a lot of space to expand on their side of story. And it also interrogates them, which puts them in a guilty light. Like they seem less credible. And also these questions are objectionable because you're really not supposed to ask leading questions at all. So don't give your opponent the chance to object to you because it also breaks the flow of your directing examination. So don't do that. And keep in mind that your job during a direct examination is to tell a story through your questions because the jury needs context before they can judge the nature of a trial. So just let your witness get in some details, make them seem like a living human, and let your witness be the star. Remember that your witness is the whole point of direct examination. So you should also have more conversations with whoever is playing the witness beforehand so you guys know what facts that you guys are going to go through, and the flow has more chemistry when you're actually presenting it. Because like I said, mock trial is more like a play than a debate. So make sure that you rehearse it a couple of times with your witness if you're an attorney. So when you are a witness, what makes you a good directing witness? So this is very much the complement to being a good attorney. When the attorney asks you a question, you should keep in mind to tell a story every single time you respond, but don't make it too long. Don't try to cram every single point that you want to get to in one response. Make sure you plan it so that the questions and your responses go through in a very organized and linear flow, because that is what makes a story easy to follow. Also, if you make it too long, the other side could object to it. It's an objection called narrative because if you go on and on, technically there's a time limit. You don't want to waste that time. And it's also just very confusing. So as a witness, you need to keep in mind that you are playing out a compelling character. For example, if your witness is a wrestler, you might want to put up some wrestling posters on your wall when you are opening your Zoom, and put a towel on your shoulders. Just be in character. Like I said, it's more about honestly, mock trial is more about drama than debate. So just try to act out the character, be interesting, be fun, be memorable, so that the jury remembers you. And if the judge likes your persona, chances are you're going to be given a higher grade on your performance. Now, I always like to keep in mind the 30-word rule when you are giving a response as a witness. So one huge mistake that beginner teams make is making their direct examination responses too long. Because when you're not that experienced yet, you don't really know how to cut up the content in a coherent flow through different questions. So you always try to cram like all the information you want to express in one single response. So remember, don't do that. And the 30-word rule helps you with that because it basically states that witness responses should not be longer than 30 words because otherwise the judge will lose focus. For example, an example response would be like, after I got home from work, I fell asleep, only to wake up later to the overwhelming smell of gasoline. And that's when I realized that my house was on fire. So, for example, that's a response that is short enough to be memorable, but also long enough to give you like enough details for you to follow up. Like it's enough to make it interesting and it does provide informational value. So when you plan out your responses as a witness, just remember, don't go over 30 words because if you go over 30 words, people are going to forget what you're saying and that's wasted time and wasted effort. Now, we're going to talk about introducing evidence for your direct examination. And this is for attorneys mainly, but witnesses pay attention too because in another round of mock trial, you may be an attorney. So everybody has to listen for this. Make sure to introduce evidence before you screen share anything or cite anything as evidence during your direct examination because you cannot expect the jury to understand what the evidence shows right off the bat. So the procedures is that you need to establish that your witness knows what the exhibit shows and is familiar with the exhibit and that the exhibit hasn't been altered in any shape or form. So because we give you the case packet, there's going to be content and information in the case packet that you may want to introduce as evidence because there's always different exhibits like exhibits A, B, C, and they're basically different objects that are somewhat involved in the case. So when you try to introduce these as evidence, remember to ask first permission for screen share, and then you need to ask, as the attorney, you need to ask your witness, like Mr. or Mrs. whatever, Miss whatever, do you know what the exhibit shows? Like, are you familiar with the exhibit? And has the exhibit been altered in any shape or form? Make sure you ask these questions to your witness so that it's made clear to the judge that the witness knows what's going on. Otherwise, the other team will object. And when they object, it breaks up your flow. So just try to not get any objections. Also, you need to ask for permission to enter it. And every single time you plan to enter an exhibit as evidence, make sure that you are prepared for potential objections by the other side. Because just because an exhibit is in the case file doesn't mean it's like automatically admissible, which means acceptable in court. Like just because we put it in the case packet doesn't mean the court is going to accept it. Everything is hearsay. So you need to find exceptions for hearsay within the IMTA rules of evidence list. And before you introduce something, just think about like what point you're trying to make with that evidence, with that exhibit. So try to outline as many potential objections the other side can make as you could. That way you can respond very clearly and coherently when they call the actual objection. That way you could get your evidence entered. Now, finally, we're going to talk about expert witnesses. They're one type of witnesses and they're very, very important because they're there in every single case. So the difference between expert and lay witnesses is that lay witnesses cannot testify towards expert opinions. For example, if you want to get the point that a spark from the exhaust caused the fire, you're going to need an expert witness to make that claim because everything the expert witnesses say in court is like indisputable. they lay out the facts. They cannot, unless that fact is made up, like not in the, as in like it's not in the affidavit, you cannot counter an expert witness. They have all the authority. So expert witnesses can testify to expert opinions, but they have to be introduced first. So you need to introduce to the court that this witness that you're about to have a direct examination with is an expert. So how exactly do you introduce an expert? So expertise must be established before moving to enter an expert. Expertise can be established with questions asking for their knowledge, skill, experience, training, or education, and usually a combination of all of these is better. And it should be established in the direct. So, for example, when you are entering your expert witness as an attorney, what your first few questions should be their names, and then you should ask about their skills, their experience working, what trainings they've gone through, and their educational background within the first few questions. And upon establishing these and getting those responses, you should move and say, now the defense or the prosecution moves to enter this witness as an expert witness. And then the court will either grant it or call objections and ask you further questions. But most of the times it's granted because that's just how you introduce an expert witness. And also things like the knowledge, skill, experience, training, or education, these facts about a witness is not made up. They're always included in our case packets. So just go through our case packet for that. And don't make anything up, because then you might be objected and you could be. Okay, I actually don't remember the exact. I'm so sorry. Please stop drawing on the screen. Yeah, thank you. So if you don't, you might be impeached, right? That's the word, impeached. You could be impeached, and that loses all of your credibility as an expert witness, and that's very, very harmful towards your case in general. So make sure that your witnesses don't make up things that counter what's said in the affidavits. And this is especially so for expert witnesses. So my part of today's lesson is done, and I'm going to hand it over to Jerry to continue explaining different types of direct examinations.
Hey everyone, I'll be taking over right now, so just give me a second. Okay, can everyone see my screen? Yep, alright, so I'm gonna go through some more detailed thing about mock trial, a specific section, which is cross-examination. So first let's do a little recap of trial structure and what we're gonna talk to now. So as we said, opening of the court and then all the statements being made, and then it's going until the examination of the witnesses. And here, the examination of the witnesses is separated into two parts: the direct examination, which is you directing your own witness, right? And this cross-examination is by the opposing counsel, the opposing attorney, to ask the witness questions. So that's the two part that we're going to focus on today. So what is a cross-examination? It's, as I said, opposing counsel's opportunity to get a witness to say what the attorney wants them to say. So you think about it. If you're talking about, I think this is the only debate part in mock trial, a little bit alike, that you have to ask a person that's being unprepared, and their response is unprepared as well. So this is some of the most important and difficult, and I think mostly the fun part about mock trial. And you can introduce facts to ask the witnesses questions to get something out of it, and you can attack the witness's credibility through this process. And so let's say what makes a good crossing attorney. First of all, you have to control the witness, right? In cross-examination, we usually want to avoid open-ended question, or we say leading question. Usually we want to give a question that can be answered with yes or no, because that will be much easier for you to control the witness. If you think about it, if you're asking a witness, how do you feel about this thing? They can yap or they can talk a lot about what they want to talk about, and this is using your time. So it's not very efficient, right? So you want to get something out, you have to use very strong questions with a yes or no, but keep in mind that you do not have to be very rude or aggressive, else there's gonna be a objection called badgering the witness, right? So but being polite is one of the foundation of cross examination. Why being polite that you can force some answers out of it is a good crossing attorney. And the goal is to get the witness to say something they do not want them to say. For example, in their direct examination, they're avoiding a specific part in the affidavit or in the case package that's not very good for their side. So you're there to attack that side to get that part of the story out of the witness's mouth. So as I said, the witnesses are under oath, and you can use the affidavit to contract and to get something out of it, right? So that's the best part about cross-examination. And let's say writing a cross-examination, of course, it's not going to be easy, right? Because you don't know how the witnesses would respond. So it's quite difficult for you to control the witness. But usually we'll have something called pockets. And the pockets is very organized. It's sort of like a main idea of how you're gonna ask a series of questions. And which the signpost we'll talk about later with a specific example. But that's basically stating what's the main point of these series of questions. And once you have a series, for example, you're gonna ask the witness, you're gonna say a little statement, but this statement don't be too long or don't express any opinion. Just say, now we're gonna talk about blah 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 blah. So the judge and will know that what you're gonna talk about and how you're gonna ask it, right? So and um through these part, you're gonna use leading questions with a yes or no answers, and the series of questions usually has to be very logically connected, and that's what I like about cross-examination. For example, at the beginning, they might not know what you're trying to talk about. You're luring the witness into a loop that you created, right? They probably don't have no idea what you're going to talk about or ask them at the beginning, and then you keep on going asking, and bit by bit, every time they don't know, you say a little part about what you're trying to talk about. So that little part they can only answer with yes or no. So they're gonna keep saying yes, 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 and then going over, and then you're gonna finally ask the ultimate question, or there's gonna be a main question that directly supports the concepts of your entire pockets. And sometimes, usually, when you have a logically connected prior questions, they kind of have to say yes to that one. So that's kind of like throwing a logical sense to get something out of from the witness, right? And so when you're writing this cross-examination, you have to figure out what kind of point that you want to ask. But you don't want to be too direct, because the witness they know you're asking this question for the purpose of helping your side. So they will fight a lot. And fighting, if the witness is fighting too much, definitely increase the difficulty for you to control the witness, right? So you want to avoid that. Therefore, when you're writing this cross-examination, you want to have a clear pockets, and in these pockets, don't be too explicit about the questions, and you write bit by bit, and going further into the logical loop that you created. And for example, as I said, the little part has to be supported with relevant line numbers in the case package, because if the witness saying no, they're denying it, they're denying a fact, you can pull out the line number and just straightly ask them about it. So it's saving a lot of time for you guys. So I would say writing out the line number is very effective and efficient. And here's a specific example about a cross-examination. So here, the letters are bolted are the signposts. They say, let's move on to talk about the purity of these testing examples, whether or not someone had tampered with drug samples. So see, we have a main idea of what this question is. And then we're going on to ask, Rick's drug seizures has unusually high amounts of cutting agents, right? Like, they don't really know what you're going to talk about, the purity or the tampered with drug samples yet. So it's just a fact whether it is high, unusually high amounts or not. And you have a sign number here, the line number here, meaning that it can be found in the case package, and it is a fact that it has to say yes. So they will answer with a yes here. And then see, this is how logically connected. After they said yes to unusually high amounts, you're gonna say unusually high amounts compared to original average, right? The original average of the regulated part of the drug samples, and because they said it's unusually high, and therefore they have to say it's compared to the original averages, it is high. See, and you're sort of like having a logic there, and then you keep asking, and that is only Murtaugh and Riggs seizure, right? So that part in Shirley is basically saying these two people who are the defendants in this case, their seizures are unusually high, meaning they have some problems. But because if you just straightly ask if Murtaugh and Riggs seizure is unusually high amount, and they're gonna talk a lot, you eventually has to go back to ask them bit by bit about, is it high, and is it theirs? And after they say it's high, and you have to ask them, is it theirs? So they kind of have to say yes to that one, and that's how you're using the two questions above and use the logic connected in order to get the response that you wanted from question 3. And then you move on to ask another series of logic questions. It's like, it's unlikely that these were the original amounts of cutting agents, right? Because you have a line supporter here that it's a fact that it has to say yes, or else you can impeach them. And we'll talk about impeachment later. But because they said it's unlikely that it's original amounts, meaning it's unusual, right? From the usually to unusual, there has to be a change. And then you ask, meaning that someone most likely added in cutting agents. Even if they say most likely, it's not very certain, but it gives judges a direction that you're getting something out of the witness. They can be surely saying it's not, there's nothing being changed. So you want to get the most likely something has changed into this. And I think that's a very effective way to ask it. And then at the end, usually you can ask some very, let's say, speculative or a little bit argumentative questions, saying it's possible that Rick was the one adding in cutting agents, right? Of course, gonna fight if they say it's not Rick's, but we don't care. We just want the point about possibility. It could be Rick's, right? Because they don't have a certain answer saying that it is not Rick's. So you're getting out by saying it's possible. And remember, in the criminal cases, what's the defense burden of proof is that a reasonable doubt, right? Possibility is a reasonable doubt. So here you're using the possibility to attack their entire case, which is very effective. So through all these series of questions that you've asked, you kind of like get a logical sense about how these things are being organized and how the questions are being asked, and finally getting a little bit blurry answer, but it will help your case. So that's about cross-examination, and I think it's a very perfect example for a pocket. So as I said, if the witness is being too fighty, sometimes they will just trying to argue against the point, even though you have a line number. So you wanna shorten this time, and if they said no to a specific question that's actually stated in the fact in the case package, then you can impeach them. So impeachment actually has a pretty complicated impeachment procedure, and I think it's very important for everyone to remember this. So because we have to know premises for mock trials that all the witnesses are sworn in, right? They have to say the whole truth and nothing but the truth. So that means when they say something, you have to ask them, Mr. Blah blah blah. Before this trial, you swore to tell the truth, the whole truth, and nothing but the truth. Just sort of as a post that you're attacking their credibility. They're trying to judge their credibility. So from now on, you're starting a impeachment procedure, and the judges also will know. And usually at this point, if the witnesses know that they're getting impeached, they will think back to their answer, and they'll be like, "Oh, wait, I'm sorry. Maybe I was wrong." And they will change their answer, hopefully. Of course, it saves your time, and meanwhile attacking part of their credibility, right? So that is a very, you might want to act it very slowly, or like just staring very seriously, staring at the witness, and so let them being scared or interrogated about it. And then you say, it is in your sworn testimony that whatever the statement it was, and they kind of like know it's right, and they're gonna say yes. So the repeat what the witness said is the statement that they said wrong about it, and it's a statement that you're impeaching about. So you want to make sure that they said that. So they kind of know that they said that as being in the record, and they're getting impeached through that sentence. So you say, before court you wrote an affidavit, and this in the case package, these are the facts. And say, would you recognize it if I showed it to you? and then you say screen share the affidavit or deposition, and which you will have someone to share it for you. And then you're going to ask them, this is your affidavit, right? And this is your signature. These two are trying to make sure that this is his affidavit and he knows about it. And then you will say, and so these are the procedure you're going to go through, and you're going to go to the statement that contradicts. So there's a contradiction. For example, the witnesses claims that they've seen the defendant, but the affidavit says they only see the defendant. But the affidavit say that they always see the defendant every Sunday. Not so they didn't see the defendant, right? So you're gonna use this, and you're gonna pull out the line. You're gonna say, Mr. Blah blah blah, in your affidavit, and you said blah blah blah, which contradicts to your statement right now, and they're going to say yes, and that's an objection, and therefore those witnesses lose their credibility, right? And then there's another impeachment. It's called impeachment by omission. All of the procedure I talked about just now is it's very essential. It applies for every cases, no matter it's impeachment by omission or impeachment by contradiction. You have to go through that process in order to get the affidavit in front of the witnesses to ask them. So impeachment by omission is that you're gonna screw the entire affidavit, and you're gonna ask them, where is your statement came out from? It's not in the affidavit that you signed before this trial, meaning that you cannot just make it out from nowhere. So you're gonna say, where in this affidavit does it say that? And it's the part that they got it wrong. So this is the impeachment by contradiction and omission. Usually, it's very effective to attack the witness's credibility and let them scared or just lose their rhythm of answering. I think it's very effective. However, I want everyone to bear in mind the fact is that don't sorry, just give me a sec. Don't try to use impeachment too much, because what I mean using impeachment too much is that whenever they say something wrong, you're going to be like, before this trial, you're trying to tell the truth, the whole truth, because sometimes the judge will think you're intentionally trying to deter the witnesses, which is not very good. It could be as badgering witnesses, or they just think you're impeaching about everything, and that definitely interrupts the trial's process and the fluency of the trial, right? So don't use that too much. You wanna if what they said wrong actually attacks your case theory, then you just straight impeach. But if it's something that's minor and doesn't really hurt your case, you can let it slide. Or it's one of the impeachment or their statement is kind of argumentative that is blurring the line between wrong or right. So you don't really want to use the impeachment right now because you don't have 100% sure that it's going to help you, right? So yeah, don't use that too much. Only use it at the right place for impeachment. It's very essential still. And I think we still have some time to talk about what makes a good crossing witness. Meaning, we just talked about how to ask question, and now we're going to talk about how to answer the question. So you have to stay in your character. You can't. I mean, usually you will have a pretty good character building in your direct examination because you've rehearsed it many times, or you've rehearsed it with your teammates many times. So but when you're handling a question from the opposing counsel, opposing witness that you don't know about, and you know they're not very friendly to you because they want to get something out of you, you still have to stay in character. You cannot just lose your character and feel like being scared or just it's not very good. You're trying to be consistent throughout the entire trial, so you would like to stay in your character, and you have to say the truth. Don't be frightened. You know. If you don't know, you don't know. You might have to be in a mindset that you're a witness, that your attorney will fight the battles and they will try to argue the points. You're just there to present the truth and present your side of the story, right? So what you know, what you don't know, you don't know, and you just say the truth. So, but definitely you have to know your affidavit well, because you don't know what part of the affidavit they might ask about. What you could have sort of like, you could guess about it, but still you have to get know your affidavit really well. If you bring into the circumstance, you think about it, you're a witness right now, and you're answering the question from a person, the opposing side of this competition, and they're trying to, when you said something wrong, you probably wouldn't realize it, and they said, is it your are you telling the truth, the whole truth, nothing but the truth? You kind of have a sense that they're trying to impeach you, and you have to think back very quickly. And this is due to the fact that you know your affidavit or deposition very well, and you're gonna think back and you'll be like, did I say something wrong? If you said it wrong, just correct it and just say, I'm sorry. I think my mind was not working very well today, and yeah, it was a yes your answer. Be very nice. Don't sound like you're changing your answer, but sounds like you actually said something wrong, that you're just trying to fix it. So leave a good impression and answer it very nicely, and so it doesn't, and be natural. I would say be natural. And sometimes I said the crossing witnesses, you can fight a little bit. Fighting on the critical points is very essential, but for you don't have to fight for every single question that they ask. You're not there to give them a hard time. Well, partly, but you don't want to interrupt the entire trial procedure or the fluency of the trial, or else going to deduct your point, right? So, you want to fight on the point that you want. For example, when we go back to this example of cross-examination, when, for example, they say risk seizures are essentially high amount of coding agents. You really don't have to fight for that because it is clearly stated in the case package. You just say yes or no. Just be confident. So they don't. So the judge wouldn't know that you're too fighty as well. See, so you don't fight on that kind of question. But some of the a little bit open-ended question or speculation question, it's possible that risk was the one cutting agents, right? You could argue a little bit more, explain yourself more about it, right? And yeah, I think that's about how a witness is how to answer it. You definitely have to fight, but don't fight too much. And you also want to advance your side of the case. While you're fighting, maybe you bring up some of the points of your side and you could explain for yourself, or you're trying to argue their case during your response as that you're fighting. So I don't really have an example right now, but you can think about it. When they're asking you something that attacks your case theory, you can just argue. Like, it's like a debate. You're trying to slide away from that. You could turn the question around, or you could discover another path, but just solve this, right? That, but when you have a chance, don't fight too much. And as you say, how to fight is that you're a character for your witness. Your humor, sassiness, all possibility ways to fight. The yes sandwich is a very classic example to fight. You start with a yes. Yes, I believe that's right. But blah 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 blah. Here, let's go back to the same. It's unusually high compared to regional averages, right? Although it's a fact, you say yes, but I think the high amount does not really matter. I think there's always a possibility, or I think you could say I think it's quite common that sometimes it's unusually high because we couldn't control this sort of condition. Sometimes you're delaying the time as a witness. You could delay sometimes because it's the opposing counsel's time, right? So you could delay the time by saying a lot and just saying yes, but blah blah blah, blah and give explanation. But the explanation don't be too absurd and just be reasonable and within the context. So, for example, there's an example. Yes, I did have a headache, but a bright yellow spandex is hard to miss. So that's a yes to your answer. You still have to say that you're still going to show that you're being very corruptive. So you have to say, yeah, that's a yes to your answer. And so that keeps you a very good witness and very responsive. But while you're delaying their time and explain a little bit about your own cases. So that's a good way of answering as a witness. And allow this, yeah, as I said, this allows to explain more but still answering the question. So when the attorney, if they're a little bit too annoyed at you, and usually when you're saying, oh yes, but I did blah blah blah, and why are you giving the explanation, they might cut you off, and that's not very friendly, right? It's going to show a very bad impression on them because they're not letting you to talk. So that's why we said this also a attorney is responsive to don't cut your witnesses off. And when you hear the opposing counsel using witness control, you have to listen you're fighting. Or sometimes with the judges, you can tell from the judge's face that maybe they think your question is too long or they're getting a little bit annoyed, then listen you're fighting. So you gotta pick your battle. As I said, pick your battle, only fight a little bit on the critical part, and the minor part just let it slide away. So you have to consider witness position when deciding when to fight. And if you're a third party, then you should be a little more polite, cooperative, because you're being invited to the court, you're not relevant to the case, so you don't want the judge to think that you're hiding something. You're just there to tell the truth, present the truth. But if you're the defendant, of course, you're getting charged, right? You're going to prison. So it's reasonable for you to have a fight a little bit more. And remember, to win this round is less about proving that your side is right, but rather earning more points. Earning more points meaning giving a more positive impression on the judges. So fight tokens to start with, 3 to 5 fight tokens. Use a token each time you fight, and just as I said, maybe these 3 to 4. For example, if the witnesses have 3 pockets or 4 pockets of questions, and you fight on the essential one of that pocket, the facts you don't have to really talk about a lot. And I think objection we will leave it to next lesson. But so far, does anyone has any questions? Yeah, I see there's one. How we cover up mistakes on our side in the case file. Okay. As we said, how to cover, this is a good question. How we cover up mistakes on our side in the case file. It's very good that you know the mistakes of your, like, the weak part of your side, right? But something more important is that you don't cover it up. A good strategy is that in your own a basic strategy is that you avoid it in your own direct examination. You don't talk about it with your own witnesses, and you're trying to avoid about it. Just let it slide and only talk about the part that's beneficial for your side. But of course, the opposing counsel is going to ask you about it, right? If you're a witness, then as I said, you could get alternate explanations. You don't have to follow their direction. You can simply just turn it around, or give another pass, and just trying to argue a little bit, but reasonably argue it, right? So let's give a, oh, I see another question. Supposed to wear the formal advocacy dress during the, okay, that's a very good question. So as we said, the witnesses needs the character, right? So what I mean by the witnesses need the character is that sometimes you will, for example, we usually do something called cross-dressing mock trial. Maybe a guy, he will pretend to be a female character because the gender of the witnesses is not being set in the case file. So you could dress up no matter how you want, or you add a little bit of accent into it, some funny accent, and these are sort of like a character that you could build. Let's say, for example, this person is a shop owner, and maybe let's say a meat shop owner. You could bring it a little bit with a accent that's like very rude or low voices. You guys could imagine how a meat dealer is, right? And also your dressing, you can dress, for example, you have a nice hang behind your wall as a costume, and you can dress in the costume of a meat dealer. I think usually they get those boots and things. Of course, you're gonna show your whole body, but like you can dress up. So you don't have to be very formal, but you dress as your character. And is there any other part that you guys are not very, so yeah, but just to give you guys notice that lawyers, the attorneys still have to dress very formally in the dress code. But yeah, witness doesn't have to. And I think we can talk a little bit more about how to cover up the mistakes on your side. So usually you will prepare your witnesses to answer about the weak side of the facts. Let me give you a scenario. For example, this case package saying that this man has a schizophrenia, he has mental issues, and he went out, he killed someone, and of course the prosecution is going to claim that he killed someone, right? But the defense is going to claim that he was mentally ill. He wasn't conscious while he was killing someone, and this is being set by the rules in mock trial. Usually, it's the American mock trial system that if a person is having a mental issue or they're having schizophrenic, then they're not under the condition that they're not going to be charged with first degree of murdering. So that's sort of like an explanation that you could slide away for your witnesses. So you can think about it. The prosecution, of course, you have to argue that he was mentally ill at the time of the crime, and the defense has to argue that he was he was mentally ill at the time, and oh, sorry, the defense did argue that he was mentally ill at the time, and the prosecution argued that he was not mentally ill at the time. He was conscious and he intentionally killed someone, right? So there's actually a very huge mistakes about each side is that you cannot prove whether he was conscious or not. So you have to use some, for example, witnesses idea. For example, his mother. His mother definitely know that he has schizophrenia, right? And so as a prosecutor, you're gonna ask, while when he left, when the last time you see him, was he schizophrenic, or before the action he taken, was he in a mental was he in a mental issue? And through these questions you're going to ask about, and they're going to say, yeah, maybe he was, yes, he was in the mental issue when you first left him. And then, and you ask some person, maybe someone who witnessed the crime. You're going to be like, is he acting weirdly than someone else? Is acting unusual? And these are all going to prove that he is schizophrenic. And of course, for defense, you won't know, right? Um, I'll just finish talking about this real quick. For defense, you won't know whether he was mentally ill or not, and you want to prove that he was. So you're gonna speak by his own 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 words. His or someone else, his doctor, saying that he's always mentally unstable. He could be he could be in a mental state every time, right? So that's sort of like an alternate explanation. You're trying to argue it against. The last time we did a trial, the man had given two time periods, but after through observation, realized that he said one certain and the other just an estimate. But after thorough, he said one. So you're saying one is certainly right, and the other is just an estimate that you could, but you want to use both, right? Um, so you want to, if they ask you about it, if the opposing counsel ask the witnesses about the time periods they're saying, if they're trying to say that he just estimated one of the periods, then the witness has to argue. He might be saying why I estimated and how this estimation is reasonable through some of the methods or whatever he used or whatever facts that he think is within it. So you're trying to make an explanation for this answer, right? So I think that's something you could consider, even though they trying to attack that you only estimated it, and it's not a factual thing, but you can still answer it with saying that oh, my estimation is correct, even though it's not fact, but it's reasonable, right? So you could say something like this to like object it. Um, yeah. Any other question? I think we're almost on the time, so I would take a few more. You can ask me any questions, even though it's not being covered for in this lesson, or just some general questions about mock trial. We're all open to answer about it. This question about time limits. I'm not really sure about this this competition, but usually there is a time limit. Sometimes usually it's section by section. For example, the cross-examination has to be how long, it cannot be exceed how long, and you will also have a timekeeper on your side to keeping track. If there's sometimes very interesting that if someone asks the question and he only asks one or two questions and the witness being fighting too much and they're arguing on that question for too long and the time was up, then of course it helps your side and you're gonna say it's time up and they cannot ask further questions. So yeah, time is very important. So if not, then I think we're good to go. We're and this end of this coaching lesson. Thanks everyone.